Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Another episode of Time is Not on Your Side, a podcast dedicated to bringing you legal topics with a real world perspective and application that you won't find anywhere else. I'm Robert Eckard, board certified business litigation attorney and government investigation specialist with an LLM degree in international law and business. So, how do I protect my sensitive business and confidential and proprietary information from being disclosed to third parties? The answer is you might need a rock solid non disclosure agreement with those you share that information with. Today's topic: why non disclosure agreements are so important. Non disclosure agreements, sometimes abbreviated as NDAs, are some of the most important agreements that a company could use. At the same time, they could be some of the simplest agreements to put in place. Today, I want to take a deeper dive into non disclosure agreements, what they contain, and why they're important. First, what is a non disclosure agreement? A non disclosure agreement is an agreement where one or both sides agrees to keep something confidential and from using that confidential information that was obtained from the other party. There are generally two types of NDAs. One, unilateral NDAs where only one side must keep something secret, or two, mutual NDAs in which both sides must keep the information received protected from improper disclosure. The choice between a unilateral and a mutual non-disclosure agreement usually depends on the kind of deal and disclosed information. For instance, in a business sale, a seller typically makes all disclosures, so the seller asks the buyer to sign a unilateral NDA. In a proposed manufacturing agreement, for example, the manufacturer may provide information about his services while the contracting party may provide formulations. There, the parties will probably use a mutual non disclosure agreement. Two, what's in a non disclosure agreement? The typical non disclosure agreement is pretty short, maybe even just a few pages or even several paragraphs contained within another document that the parties sign, such as an employment agreement, independent contractor agreement, or non compete agreement. Having read and drafted a lot of NDAs in my career, I've seen a number of things pop up over and over again. These are listed out here today, A through H. A, whether the non disclosure agreement is mutual or unilateral. B, a definition section of the information that must be kept confidential or secret, usually defined as confidential information. For example, it might say such information includes all business, financial, and other information marked or designated by such party as confidential or proprietary. Confidential information also includes information which, by the nature of the circumstances surrounding the disclosure, ought to be in good faith treated as confidential, whether identified under Chapter 688 of the Florida statutes or not. That's the trade secret provision. C, there may be a carve out section from the definition of confidential information. For example, one, information that's already in the public domain when disclosed or enters the public domain after. Two, information that the disclosing party later makes public. Three, information that the receiving party knew prior to receiving any confidential information from the disclosing party, and information that the receiving party independently develops without reliance on any of the confidential information from the disclosing party. D, the scope and purposes for a party's use of the confidential information. E, the limitations on how a party might disclose and who it may disclose to. F, the term of the NDA and what the parties must do after it terminates, which is usually return it or destroy it. And G, the available remedies of the disclosing party in the event of a breach, which almost always includes equitable relief. H, a statement that the NDA does not grant any ownership or license rights to the confidential information. Now, they may contain other provisions mentioned above, including non-circumvention provision, but what I covered is typically seen in a typical non-disclosure agreement. Three, the third area we want to discuss today is our template NDA agreements a good idea? Yes or no? NDAs can be very formulaic. And a simple but novice mistake would be to use a unilateral NDA form when a deal calls for a mutual NDA form. This mistake could be very costly and devastating for your business. Additionally, there may be very specific things within an NDA that need to be changed or modified depending on the deal. For example, one of the NDA provisions I see changed most frequently is third-party disclosure limitations. Some of these NDA allow for disclosures to an employee of the receiving party, but the receiving party needs to also have someone sign that agreement. The disclosures might also be allowed to attorneys, financial planners, and or government officials. And we'll want the third parties to be bound by the non-disclosure agreement. And so the disclosing party may want that third party to sign the terms and conditions of the non-disclosure agreement. These kinds of bespoke or made for particular provisions may make it into an NDA or not, but you got to be aware of it. The fourth and final topic of our discussion today is, why are NDAs valuable? People and businesses generally do not have any obligation to secrecy unless they sign an NDA or similar confidentiality agreement. Anything one party provides to another in a transaction or transaction can lose its confidentiality. A very common issue I've seen over the years is when a company asks for an NDA after holding a preliminary discussion and exchanging information. While this is certainly helpful, it's too late. Businesses that are smart plan ahead before agreeing to share and disclose confidential or proprietary information before starting talks. Let me give you an example. Say Creighton is the sole owner of a company called Worthy Athletics, LLC, and wants to sell it to Jack. Jack will do his due diligence and ask for Worthy Athletics financial information and customer list. If Creighton provides this without an NDA in place, Jack may simply take the customer list and use it for himself and walk away. Nobody in Creighton's place wants to be in that position. As I said earlier, and it's important to note, here again, that NDAs are not the only source of confidential protections. Sometimes you'll see confidentiality protections in letters of intent or in the ultimate definitive agreement like a purchase agreement. The problem with this is that by the time the parties sign a letter of intent, they likely will have exchanged information that's confidential and proprietary, and this needs to happen before the final agreement. Additionally, the average letter of intent section of confidentiality may be a short paragraph as versus compared to a standalone NDA. The takeaway is that do it ahead of time and as early as possible and in a comprehensive manner. NDAs are not the only way that companies can protect their confidential information or trade secrets, and it's possible to sign an NDA with provisions that actually put trade secrets at risk. But in general, without an NDA in place, parties have no reasonable expectation that what they say or hand over will actually remain theirs. NDAs also do not need to cost an arm and a leg, but spending a little upfront has tremendous upside for the protections of valuable, confidential, and proprietary information. In closing, it's important to mention whether using a standalone NDA or another agreement that contains non-disclosures, they should include the following standard provisions: a venue in the event of litigation, where the litigation will be brought, an anti-waiver provision, a merger and integration provision, a no modification provision, a choice of law provision, and a provision for the recovery of attorney's fees in the event a lawsuit is filed. Finally, a disclaimer provision. Now, I hope this information was helpful. Remember, plan ahead and prevent disclosure of confidential, valuable, sensitive information until after a non-disclosure agreement is signed by all parties. This concludes another episode of Time is Not on Your Side. Be sure to hit the like button on your social media platform and drop me a message if you have any comments or questions.
You've been tuning into Time is Not on Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.